only. We also spent about 18 months reviewing the GAFTA container contracts, GAFTA 88 and 89, which many of you will be familiar with because it's our container contracts that are often used for transporting pulses. And the purpose of the updates were very much to align both the contract drafts with the practice in the container industry. And the terms of GAFTA 89 were amended from free on board to free carrier to reflect the trade practice. So just to sort of summarise some of the changes for GAFTA 88, so the main changes, this is a CIF contract, cost insurance freight. The main changes are as follows: that quality has been amended to give optionality to certify quality final at time and place of stuffing, or alternatively at time and place of discharge. And it's up to the parties to specify at the time the contract is entered into which they would prefer. The period of shipment has been amended to clarify that the bill of lading can be dated on board or when the goods are handed over to the container consortia for shipment. Again, it's up to the parties to specify which they prefer. Weighing has been amended to give parties the option as to whether it should be, again, certified as final at stuffing of the container or at the time and place of discharge. And a new clause relating to GAFTA 124 has been inserted, so it now incorporates the 124 sampling rules. So GAFTA 89, the full container loads on free carrier terms. So the main changes have been to clarify where the place of delivery is to be and to include the definition of the meaning of free carrier under this trade. The delivery terms also specify with a lot more detail the obligations of buyer and seller in respect of delivery of the containers, the pre-advice required, the stuffing of the containers with the goods. Also, quality and condition has been amended to provide for it to be certified quality final at time and place of stuffing of the container to reflect the common practice in the trade. So the delivery period clause is also drafted to clarify that the applicable bill of lading date will be when the goods are actually received for shipment and not necessarily on board a vessel. And the extension clause has been amended to provide the right of extension for both seller and buyer in relation to their performance of the obligations under the contract. Now, all of these changes for GAFTA 88 and 89 have also been presented to GPC's Contracts Committee for their consideration as well. But it's my understanding that they have decided at this time not to make any changes to GPC number 1 to reflect the changes that the GAFTA contracts have made. Circle clause, so this has been an amendment over the last couple of years, is just to clarify that effectively where a circle has been established after the goods have been appropriated, that the settlement should be based on the appropriated quantity. Some other changes: GAFTA 123, 124 and GAFTA virtual hearings. So GAFTA 123 weighing rules, these have been updated about 2 years ago. Predominantly similar to how they were before, but now also allowing for other methods of weighing actually to be acceptable. The GAFTA 124 sampling rules, these have been out for consultation over the last year. They have just been signed off by GAFTA Council in January, and these should actually go live. I believe the next contract update is going to be in March this year, so fairly soon. Again, not huge changes. We actually did quite a big review, but mostly it was the language that was actually changed to make things clearer for people using the clause. What we did do, obviously during COVID, is we had to amend our 125 and 126 rules to allow for virtual hearings, because this wasn't something that was actually allowed under GAFTA arbitration rules. And so now we have the ability for the arbitrators to appear all virtually or all in person. We've always had the ability for witnesses to appear virtually, such as via video comm. And this has generally been regarded as quite a positive development, although I have to say I'm very pleased that most parties who are coming to a GAFTA appeal board are still keen to actually appear in person. Notices. This was quite an interesting clause change and one that took a reasonable amount of debate, and it's been actually prompted by the growth in electronic trading platforms. Many of you will be familiar with different forms of electronic trading platforms that are being used by GAFTA members and non-GAFTA members. And the original clause used to state that notices could be exchanged by email or by fax or telex, and sort of give a list of examples. And the concern that had been raised by a couple of electronic trading platforms was this somehow suggested that their method wasn't as valid as these older forms of telecommunication. And we had a debate at the arbitration committee about, effectively there were two ways to go. We could go down the route of continually amending the clause to add in every single new type of electronic communication, whether this was WhatsApp or something else, or we could simply limit it to email and then say, and anything else that's mutually agreed between the parties, so that we didn't have to constantly go back and revise the clause every time new methods of communication were actually developed. So that's actually what we've done. So email is the example, but anything is acceptable as long as it's agreed to by the parties. A few other wider contractual issues we've been looking at. Force majeure. I feel like I've spent several years now wading through force majeure, what it means, what are the implications, and yet surprisingly it has not come to be the issue that perhaps we thought it would be at GAFTA. So obviously during COVID this was raised a lot by parties to GAFTA contracts about whether COVID was going to be an event of force majeure, whether this would mean that the contract was actually going to be cancelled or not. In the event, we have had very, very few claims of force majeure related to COVID, which has surprised us because we thought we were going to get lots. But it appears that most parties have actually been able to settle, have been able to work out their differences, have been able to make things work throughout the process. Last year, the UK government took out a review through the Law Commission of the 1996 Arbitration Act. And the Arbitration Act is the governing law that, for GAFTA 125 and 126. It's not intended to be a wholesale review of the law, more of an updating. And GAFTA, both ourselves, both our arbitrators, and also through our chairmanship of the FCA, which is the Federation of Commodity Associations, put in our own submission about what we thought the changes should be, where we thought things should actually be left alone. And the FCA, for your information, consists of ourselves, Phosphor, GPC, the Rubber Association of Europe and the UK, the Sugar Association, coffee, cocoa. So it's all of the soft commodities who are based in London or in Liverpool and who issue their own contracts and carry out arbitration. One of the other tidying up exercises that we did over the last couple of years was to look again at the GAFTA Charter Party and also the associated arbitration rules 127. We found from consultation with our members that the GAFTA Charter Party was really not being used and had not been used for several years, and neither had the 127 arbitration rules. So both of those have actually been removed from the GAFTA book and website. This is always one that makes us laugh, but it isn't always funny, if I can say so. Increasingly, we come across disputes where parties contract using WhatsApp messaging, for example, or WeChat or the equivalent. And it's very common for emojis to be used as part of that contractual negotiation. The issue that we find, and our arbitrators find, and this becomes a regular thing now where they get printouts of various emojis, is trying to actually work out what they mean. And it's just really a sort of a gentle tip to be careful, because emojis don't always mean what you think they might mean. So does this mean yes, this is a good deal, or does it mean yes, I'm going to go ahead and actually do the deal? You know, is okay, I've received your offer, or is it okay, yes, I'm going to go ahead, this is acceptance. And remember, of course, the background to this, that under English law, that commodity contracts don't have to be in writing at all. They don't have to be signed or stamped. They can be done by text, by phone, by WhatsApp, even by emoji. So actually, these things have real meaning. So I think probably the biggest tip I can give you all here is be really careful how you use these emojis, particularly when there is no common definition of what they might mean. So, you know, if you get this little smiley emoji, does that mean someone's saying, yes, this is a great deal? Or does it mean, you're crazy? What do you think you're doing, offering me this at this price? And is this a pray in your dreams? Or is it high five, we've done a deal? There is a huge potential for misunderstanding, shall we say. So please be careful if you use WhatsApp or its equivalent and emojis, and just do bear in mind it can and does form a legal contract under English law. Because of that, I thought I'd just very quickly highlight there are some GAFTA training courses coming up for those of you who are thinking, oh my goodness, I didn't know that, perhaps I better find out a little bit more about GAFTA contracts, how they work, what they actually mean. Obviously, we've resumed our face-to-face training courses. We have a training course coming up both in Argentina in March and another one in April. We have some online training courses as well. We have a regular Know Your GAFTA Contracts seminar, which is a 2-half-day seminar, which happens generally every couple of months. And we also have our Agribility platform for sort of very short, bite-sized portions of learning that take perhaps 30 to 40 minutes. It's very cheap, it's very quick, easy to do. You can sit and do it on your mobile phone if you're caught in the airport, and you can just actually work through a module at your own pace. And this just gives you here, you know, sort of an example of some of the things we cover. So shipping the goods, appropriation and default, common difficulties with shipping documents, conducting an internal audit, enforcement, fumigation, futures and hedging, contract terms, insurance, lay time, and many, many more. Just briefly about the approved registers, as hopefully most of you will know, we now have approved registers for all 3 categories of GAFTA technical firms. So that is for our superintendents, our analysts, and our fumigators. All of those companies who are on the approved registers have to actually go through an audit. This is carried out by an external company, NSF, who's a certification body, an international one based in the US. Or companies can also, in the case of superintendents and analysts, supply an ISO equivalent standard. But it's really been a move over the last 5 years or so to actually drive up the standards in our technical firms, particularly in a response to a demand from the trade of wanting to really increase standards in our technical firms. I have to say it's been very well received. It's really driven up our membership in these categories as well. And we get a lot of interest where we go in terms of companies finding out more about what's actually involved. Last year, we also launched GAFTA's Sustainability Pledge. This is an option for GAFTA members only, for members to sign up to the GAFTA Sustainability Pledge, to make a public commitment of their company's commitment to working towards sustainability. And in brief, it consists of a web page with an online resource of sustainable initiatives that might be relevant to you. You get to choose the two that you would like to sign up to, because obviously GAFTA members vary hugely. You know, we have, you know, sort of members who are an individual, and we have multinational members, so what suits one is certainly not necessarily going to suit another, and so there's a great deal of flexibility in terms of being able to choose the initiatives that you want to work towards. You have to give us a commitment that you're going to work towards these particular goals, that you will give us an annual update about what you have been doing to actually meet the requirements of that particular initiative and the pledge, and in return we will publicly list your company on our website as being a GAFTA member that's working towards sustainability, give you the use of this particular logo, which you can then use on your own material, your tenders, your CSR reports. And then for GAFTA, it gives us the ability to have a better overview of what all of our members are working towards. And whenever we're talking to policymakers at the UN, for example, and they say, okay, well, what are you doing? What are you doing, GAFTA, to try and encourage all your members to work towards sustainability initiatives? Give me an example of what your members are doing. We're able to say, here, this is what they're doing. These are all the members who've made a public commitment. This is exactly what they're doing. And we have lots of other members committed to working towards it as well. Very briefly on trade policy, which many of you will know is a key feature of GAFTA's work. My colleague, June Arnold, unfortunately couldn't be here this time, but we are very involved with WTO, FAO, and the International Agri-Food Network. Saw the picture of Robin outside from a previous IPGA event, and we particularly work on the importance of international free trade, and also the importance of science, sound science, underpinning regulatory decision making. We regularly contact governments and policymakers where decisions are made, particularly those at short notice, which cause trade disruptions and are not necessarily based on sound science. We were very involved with the UN Food Systems Summit 2 years ago. And also we've recently had our observer status confirmed at the IMO, which is also very useful in terms of any decisions that might be made that affect the shipping of all of the commodities that we're involved in. Very briefly, an overview of some of the events that are coming up in 2023. So I know your GAFTA contracts course, that's an online one. I mentioned we have a course in Argentina, Trade Foundation course in London, another Know Your GAFTA Contracts online course in July, a shipping course in London, contracts course in Warsaw, dispute resolution in Kiev. It possibly may not be Kiev. We shall continue to keep an eye on the situation as it goes on. But really, I think what I wanted to take the opportunity today to do was really, first of all, to reiterate my opening statements, which is, it is an honour and a pleasure to be here again. I really enjoy working with IPGA and also GPC. We hosted the event for World Pulses Day at the GAFTA offices last week in London, and just to say, GAFTA is here for you as a trade association, and what we do is very much shaped by our members, and that we are always listening. So if you have any questions, please let me know. Thank you. Yeah, I'm done. Do you want to do questions now or later? Do you want to do questions now or after Sharon? Oh, Sudhakar.
I'll get the mic around you. I'll ask a very basic question for the benefit of my trader friends and brethren. What would be one advice which you give to traders based out of subcontinent to avoid getting into problems and not going to GAFTA?
That's a very good question, Sudhakar. Thank you for that. First of all, and it sounds easy and obvious, but you'd be surprised how often it isn't done. It is read your contract. And the second point is, if there's something in there that you don't understand, and there often is, ask. Ask questions. Ask questions of your counterparty. Potentially ask a lawyer, ask an arbitrator such as Shailendra Bardia about what a clause actually means. But reading your contract and understanding what you're actually signing up for would probably prevent the vast majority of difficulties with contracts. The other things that I would suggest, and these are very practical tips, is if you're entering into a contract with a counterparty that you don't know, first of all ask yourself, are they a GAFTA member or not? If they're a GAFTA member and everything goes wrong and you end up in arbitration, they are very unlikely to default on an award of GAFTA arbitration. And we have an additional sanction. We can actually expel members who don't comply with the award of arbitration. So the majority of our awards of arbitration are honoured, and the majority of the problems that we have with people not honouring awards of arbitration are with GAFTA non-members. So check whether they're a GAFTA member or not. If you're a GAFTA member, you also have access to the defaulters list, which is on our website, which means that you can also have a look at, over the last 5 years, which particular firms haven't complied with an award of arbitration. You might want to ask yourself, do I really want to be doing business with these firms if they haven't proven themselves to be trustworthy, shall we say, in the past? And then the third thing that I would recommend is when you sign the contract or before you sign your contract, just check where your counterparty is based. Are they based in a country which is a signatory to what is called the New York Convention on the Enforcement of Foreign Arbitral Awards? This is a very old convention that goes back to 1956, and there are now, I believe, over 168 parties to this. As long as your counterparty is based in a country that has signed up to this convention, then again, if it all goes wrong, you can take your GAFTA award of arbitration to the local courts and ask them to enforce it. So check those three things first. Very practical. And I saw Peter Wilson at the back had his hand up too.
Hi, Jane.
Hi.
Art working. Very good. Again, thank you very much for your comprehensive presentation, Jane. It's always a pleasure to have you break open the word around contract law. My question is a bit, how is GAFTA seeing the use of blockchain in the broader grains industry, and including pulses and oilseeds? Are you seeing an increase in the use of blockchain as an execution mechanism, and is that reducing, conflict in the contracts?
Thank you, Peter. Again, another very good question. Yes, certainly anecdotally, we are aware of many more companies, including GAFTA members, using blockchain, using a variety of electronic trading platforms to conduct their trade. We are trying to endeavour to keep very good relationships with those companies. Several of them have actually become GAFTA members. Some of the big ones, for example, like Cavantis, are actually now GAFTA members as well. And this enables us to be able to share information with them about contract changes, etc., on a regular basis. It's very difficult to give a specific answer to the question about whether it's reducing sort of difficulties in the trade. Partly because I think sometimes the things that we think are going to cause difficulties don't. And that's always a real surprise. So, for example, when COVID hit, we were convinced we were going to have deluges of arbitration claims related to force majeure and COVID. And we've had less than a handful, really. It's been a real surprise to us. Similarly, obviously with what's going on currently in Russia and Ukraine, we haven't yet seen a huge amount of cases arising out of those particular circumstances, although we are aware that, of course, there are a number of defaults and that there are a lot of discussions happening behind the scenes. And so also with electronic trading platforms, we're aware that they're being used. I believe we've had at least one case, arbitration case, that does involve evidence from an electronic trading platform, but we're talking a very low number. So possibly it could be inferred that it is preventing arbitration claims, but I think it's overall probably too early to actually say. We'll continue to monitor the situation and make sure we continue to have good engagement with all of the key platforms, so that, you know, where we can assist them and vice versa, that we're able to do so. Thank you. Any other questions?
Hi Jane, it's Sid from Savoy Import and Export. In other industries, we've seen third-party risk and questions around data privacy. Is GAFTA looking at this in terms of exchange of information of individuals and parties outside of direct contracts, and how that's being handled?
Yes, in the sense that we always have done. We don't share information at all outside of what goes on at GAFTA. So if you come to GAFTA to claim arbitration, the only three parties who know that you are claiming arbitration are GAFTA, you and your counterparty. We simply don't share that information outside, which is why having this sort of more informal discussion with electronic trading platforms is quite important, because at the moment we don't breach that at all. I don't really see that actually changing. The only exception is, of course, with GPC, and many of you will be aware that GAFTA actually carries out the majority of arbitration for the Global Pulses Confederation under its contract number 1. So those disputes come to GAFTA. And in the event of there being a default under a GPC contract, because of the way GAFTA's rules have been altered and also GPC's rules have been altered, we're then able to share that information with GPC. So not only can GAFTA potentially take enforcement action against that party, GPC can as well, but everything is linked back to either what parties have agreed to within their contract and potentially what is also covered in our membership rules if that company is a member. But we don't share information outside of that. Okay. Done? Thank you.
That was the GAFTA presentation by its Director General GAFTA, Ms. Jane Chisholm-Cont, and of course on the dais we have Shailendra Bardia. I'd like to request from the organizers and the organizing committee of IPGA, Mr. Satish Upadhyay, to please step up. Sir.
This is okay. Good afternoon, ladies and gentlemen. Before I take up my presentation, I want to reply to two questions which were raised to Jane. First was of Mr. Sudhakar Tomar. He asked, what should the traders do in this region, whether they should go for arbitration or settle outside the arbitration. In my experience, most of the pulses contracts, they are small contracts, 2 containers, 4 containers. 2 or 4 containers. So where the size of contract is small and the stakes are small, I would suggest the parties that they should not, first of all, default the contracts. If at all there is default or if there is a forcible default, then they should try to mediate and settle outside the arbitration. Because the cost of arbitration, when you convert Indian rupees into GBP pounds or US dollars, the cost of arbitration is very high, and then cost of execution of award is also very high. So my advice would be, for small contracts, one should try to settle outside the arbitration. That is the best way for the parties. Now, coming to the second point of sharing of the informations. Yes, the informations are not shared, but if anybody is defaulter of the contract, then the defaulters are notified in GAFTA circulars. So you can always check with GAFTA circulars whether you are contracting with a party which is defaulter or not a defaulter. And if you are a defaulter, if the other party is a defaulter, then you need to take reasonable precautions. Another point on sharing of information is that the GAFTA arbitration awards are also not shared, but if both the parties agree, then the award can be shared and that can be publicized. So this is my reply in respect to Mr. Sudhakar Tomar's question and also about sharing of information. Now, ladies and gentlemen, my topic is very limited, and that is arbitration clause. And I am not taking you to the arbitration rules. I am not taking you to the Arbitration Act. I am not taking you to the decided cases. Friends, most of us are international traders. When we negotiate any import or export transaction, the important considerations are we simply look at quality specifications, we look at the quantity, we look at the delivery period, we look at the price, and we look at the payment terms. We do not consider any other terms and conditions. We take these terms and conditions as in a routine way, that these are standard conditions are of no use. We also do not imagine that there are chances of disputes. The disputes can be deliberate in the sense that when there are market fluctuations, there are deliberate defaults. Or they can be by act of God, like the COVID in first instance, that there were defaults. So whenever we negotiate a contract, we should also consider how to have the arbitration term in the contract. Whenever a contract is negotiated, normally what happens, either brokers share the standard contract, and if the other contracting party is a multinational or a big corporate, they share their standard form of contract. When we receive a contract, we simply check these 5 parameters, that is quality specifications, quantity, shipment period, price, and the payment terms. We are not at all bothered for other terms and conditions of the contract. The other terms and conditions are equally important, and they are more important when a dispute arises. The contents of other terms and conditions comprise of so many things, and the important ones which I am going to deal in today's presentation is that one is regarding for all other terms and conditions, the parties adopt a specific GAFTA contract, whether it is contract 23 or 24 or 81 or 88, 89. They say that all other terms and conditions will be as per GAFTA contract. Then sometimes parties, besides adopting the specific GAFTA contract, they also, in place of GAFTA contract, they say that it is as per GPC plus contract, pulses contract. So this is regarding adoption of other contract in respect of other terms and conditions. Besides adoption of contract, sometimes the parties put a condition about arbitration clause, and they say that arbitration will be in accordance with the GAFTA arbitration. In peculiar cases, I have observed that sometimes parties say they put this condition regarding the contract, they put the condition of arbitration according to rules, and they put further condition that this contract will be governed by, say, UAE law or by Indian law. So this is really a very, very complex situation. But normally, in my experience, parties do not read these terms and conditions. They simply say that, oh, these are the formalities. They are bothered for their profit in the contract and simply sign the contract without reading the terms and conditions, without reading the documents which are referred into these terms and conditions. They never look at GAFTA 88, they never look at GAFTA 89, they do not look at GPC plus contract. So they are bothered for this arbitration clause only at the time when the dispute arises and when they receive a notice for arbitration. So my suggestion to all the members of IPJ is that they should consider arbitration clause while negotiating the contract and before signing the contract. And whenever they sign a contract, if there is reference to any particular contract or any particular document, any particular set of rules or any particular legislation, they should get a copy of that and then consider whether it is appropriate in view of their relationship with the other party, in view of the volume of the business, in view of the stakes involved, and then only they should agree for that condition. If that condition does not suit them, then they should not do it. I'll explain how you should adopt a particular term and condition, how should you go ahead. So as I said, undoubtedly at the time you consider the arbitration clause, but the most important is before signing the contract. whenever you receive a contract, whether through your broker or whether through the other party, they have arbitration clause, and normally they said that arbitration will be in accordance with a particular GAFTA contract. All GAFTA contracts have a standard arbitration clause, and that is identical. That says any and all disputes arising out of or under the contract or any claim regarding the interpretation or execution of this contract shall be determined by arbitration in accordance with GAFTA arbitration rules number 1 to 5, in the edition current at the date of the contract. So my emphasis is arbitration rules which are applicable at the time of signing of the contract. You should consider which rules we are referring to. And there is a deeming provision in the contract that these rules are deemed to be incorporated into and form part of the contract. So if there is a simple condition that all of the terms and conditions will be as per GAFTA contract 88 or 89, then you have agreed for arbitration, because in these contracts there is a standard arbitration clause. These rules further say that when you have agreed for arbitration, then no party or person claiming under that contract shall take any legal action until and unless the dispute is resolved by the arbitrators or the Board of Appeal. So my emphasis here is arbitrators or Board of Appeal. I will explain it later on, but you must be careful that if you have an arbitration clause, don't be swayed away with the advice of your lawyers that yes, we'll take a stay in the courts, we'll stop these proceedings. That is not possible. Even if you go to the court, you will be wasting money, because court will examine your contract, and if they see that there is an arbitration clause, they will say that you go to the respective arbitration body, get your dispute resolved, and if they cannot intervene in the matter. So this is another point. Then, of course, you can go to the court for a particular matter, and that is for securing your claims. So if you are having any doubt that the other contracting party is likely to run away or transfer his assets, then of course you can go to the court of any appropriate jurisdiction and seek appropriate security for securing your claim. And this is equally applicable in respect of counterclaim as well. Sometimes, especially in pulses contract, parties put for other terms and conditions GPC pulses contract number 1. This is applicable since this was introduced in 2019, and still it requires a lot of changes, because it still refers to GAFTA simple dispute arbitration rules, whereas the rules name have been changed. Now it is not GAFTA standard arbitration rules. The present name of the rules is GAFTA expedited arbitration rules. So this is just an information. Now question is, when GPC Pulse contract is incorporated, then you have to be very, very careful. You have to weigh what is your stakes in the business. If your stakes are very high, then you should consider not to have arbitration clause according to GPC Pulses contract. And the reason is very obvious. In GPC Pulses contract, the arbitration is by a sole arbitrator only. And then there is no right of appeal. If you look at condition clause C, neither party hereto nor any person claiming under either of them shall bring any action or the legal proceedings against the other in respect of any such dispute or claim which shall be heard and determined by the arbitrator in accordance with GAFTA simple arbitration rules 1 to 6, which shall be final and binding on the parties. There is no right of appeal to GAFTA or the courts. The role of the court shall be restricted to only enforcement. So this is the biggest limitation. If you are having a bulk contract or if your stakes are very high, then you must consider which arbitration clause you should apply. Now, I quickly move on to the other side. Arbitration rules 1 to 5. When you adopt a GAFTA contract or when there is a specific reference of arbitration rules, then you need to look at arbitration rules 1 to 5. And the preamble says that any dispute arising out of a contract or arbitration agreement, which is a fundamental condition of GAFTA arbitration rules, that there should be a contract in place or there should be a specific agreement between the parties that arbitration will be in accordance with the GAFTA arbitration rules, shall be referred to arbitration, and arbitrators or Board of Appeal, as the case may be, will proceed to determine all issues before them. Now, the preamble refers to arbitrators and also Board of Appeal. So, these are exclusive situations. GAFTA has a setup of two-tier arbitration. The first tier arbitration is by a sole arbitrator or a tribunal of 3 persons, and as against the decision of first tier arbitration, you can go into appeal. And if the arbitration has been, first tier arbitration has been by a sole arbitrator, there will be a Board of Appeal of 3 members, and if first tier arbitration is by a tribunal of 3 persons, then their Board of Appeal will be 5 members. And both the situations are totally mutually exclusive. Here, appeal is different than our normal understanding of appeal. Of course, the arbitration award is challenged, but it is a fresh hearing of the case before the Board of Appeal. You are entitled to make fresh submissions. You are entitled to add new documents. You are entitled to give new evidence also. And the Board of Appeal has no right to look at the submissions and exchanges at the first year unless both the parties agree. So this is a peculiar situation of appeal, especially with respect to GAFTA arbitration rules. There are different provisions in the rules which are time limits for claiming arbitration, appointment of sole arbitrator, tribunal of 3 arbitrators, appeal procedures, Board of Appeal, and so on. I am not going to deal with these rules. I am just saying that if arbitration is according to rules number 1 to 5, English arbitration is applicable and the seat of arbitration is England. Arbitration deposit is very clear. If arbitration is by sole arbitrator, there is deposit of 11,400 with a discount of 1,700 per member, and both the members then discount of 3,400. And if arbitration is by tribunal of 3 arbitrators, deposit is 15,000. Against there is theory of discount. And if there is appeal deposit is 17,000, it is likely to be increased to 20,000. Coming to the expedited arbitration procedure rules number 1 to 6, the name has been changed, and the GPC pulses contract number 1 requires change because it still refers to GAFTA simple disputes arbitration rules number 1 to 6. So this change has been done long back. And in this case, it is clear that arbitration will be by a sole arbitrator, and sole arbitrator can either be appointed by agreement of the parties or by GAFTA. There is no other thing. And once an arbitration award is given, it is final and binding on the parties. And here also the applicable law of arbitration is English Arbitration Act, and seat of arbitration is England. Now, choice of rules, which rules you should apply for arbitration. This is a decision which you have to take before signing of the contract. You have to consider the amount of cost involved. Of course, in sole arbitration, the cost is less, but you have to weigh what are the stakes and what are the points involved. And you have to decide if there are huge stakes in the contract, then you should go for arbitration by a tribunal of 3 members, because at least people will think in different way, and then there is a judgment by majority view. Another consideration is a right of appeal. If stakes are high, then you should not deprive yourself of right of appeal. And this is the distinction in rules 1 to 5 and 1 to 6. 1 to 6 does not give any right of appeal, and rule number 1 to 5, it gives right of appeal. And even after appeal before the Board of Appeal, you can go to the High Court, Commercial Court, then you can go to the Court of Appeal, and then you can go to the Supreme Court. Of course, appeal to the Commercial Court is with the leave of the court. You have to apply for the permission of the court to appeal, which is rarely granted because the English courts have got tremendous trust on their arbitrators. But in specific cases, it is not a general rule. There are exceptions. There are good leading cases where permission has to be granted. And even there are cases where the parties lost before the commercial court, but they won in the Court of Appeal. What to do when you incorporate GPC pulses contract? Now, suppose your contract is big, but still GPC, other parties saying that I will incorporate GPC pulses contract. Then you can say that, of course, we'll have an exception on arbitration clause, and we'll have arbitration not according to rule number 1 to 6. We'll have arbitration according to rule number 1 to 5. Law applicable to arbitration is English law unless otherwise agreed by parties. And if you decide for any other law, UAE law, because I have seen many cases where parties adopt GAFTA contract, they agree for English Arbitration Act, but they equally say that, okay, UAE law will be applicable. So this is really a complex situation, and in order to avoid this situation, you should specifically agree which law you want to apply. And law is relevant only in respect of arbitration procedures and governing and it governs the arbitration. So that is an important. Along with law applicable in the seat of arbitration, we must understand the difference between seat of arbitration and venue of arbitration. Seat of arbitration is with respect to law applicable, which governs the arbitration, because they are interrelated terms. And where the arbitration takes place, it is the law applicable is decided accordingly. Venue of arbitration can be different. Now, can we get this on the website? Yeah, just last minute, 1 minute only. Yeah. Now, challenge to GAFTA arbitration awards. GAFTA arbitrations award can be challenged before the English courts. Of course, leave of the court is required. Important point is they cannot be challenged in other jurisdictions. Once awards are final at the UK, they cannot be challenged. Only executions can be challenged. Now, if you get an award in India from GAFTA, which is final, there is no appeal, then you cannot challenge in High Courts, because High Court is the executing authority. Because High Court cannot go into the merits of the case. They can simply stop the enforcement of award, and there are very, very thin grounds for that. So that is important. You should never have an ex parte award. Whenever you receive an arbitration notice, you must participate in arbitration. You must attend the arbitration. Take all your challenges, fight until last moment, so that at least you can save your any claims arising against you. You should not allow the other party to take undue benefit of your ignorance, undue benefit of your non-participation. And the last important point is you should always be very careful about who are the parties to arbitration. Only contracting parties are arbitration. You should never allow the other party to make non-contracting parties to arbitration. It has very serious consequences if they are non-contracting parties. I give you an example. If your contract is by your company, which is a limited liability company, but if you allow other parties, the board of directors and shareholders also as parties to the arbitrations. And GAFTA award, the tribunal considers, okay, non-contracting parties are also party to arbitration. Then when award comes for execution, despite the limited liability of the company, even the directors and shareholders will be liable. This is technically called alter ego, and you should be very careful about this particular position, that arbitration is strictly between the contracting parties, and merely by signing the letters, merely by signing the correspondence, non-contracting parties are not made as parties parties to the arbitration. This is a very, very important precaution.
Thank you, Mr.
Thank you very
Bharti.
much.
Must apologize
Thanks a lot.
for this, but it's already over 18 minutes, 20 minutes. Please have a seat. Thank you so much. Do apologize for the shortage, paucity of time. The entire session was for 30 minutes. We've gone for over 45, almost 50 minutes. So we have a schedule to catch up with, and I'd like to request from the organizers, Mr. Satish Upadhyay, to please step up on stage and present mementos to our venerable GAFTA panel. Starting off with a memento to the GAFTA Director General, Ms. Jane Chisom-Kont. And also to Mr. Shailendra Bhardiya, with apologies, Mr. Bhardiya, sorry for about that time mix-up. Next time we'll make sure that GAFTA gets a lot more time than we were given this year. So thank you once again. Quick moment of photograph.